So who knows the difference between an expert witness and a fact witness? Fact witnesses are called just to testify about what they know. What they've seen. They're not allowed to offer opinions or conjecture. Whereas fact witnesses are being paid for their time. Absolutely. So there are so many courses and so many resources out there for people who are wanting to be expert witnesses. I wanted to talk just a little bit about the case law that underlies being an expert witness for those of you who haven't been expert witnesses, or maybe those of you who do, just because you need to be aware of them. So if you're acting as an expert witness, some of the things to be aware of are always tell the truth. If asked how much you're being paid for your testimony, what do you say? I'm not being paid for my testimony, I'm being paid for my time. Just memorize that line, you're good. And always, always, always work with the attorney to be prepped so that you know what you're going to be asked and you know how you're going to answer not only for testimony in trial, but also depositions. Let's talk a little bit about the case law. Frey, the Federal Rules of Evidence and Daubert are the three that we need to be aware of. Frey is the case that really set the stage for general acceptability. So it provides that expert opinion is based on scientific techniques, and you have to have those scientific techniques to be admissible only if the techniques are generally acceptable in the field. It's based on the 1923 polygraph test used in the Frey decision. And the court held that, in essence, it dealt with the systolic blood pressure deception test. And the argument was, is this something that's generally accepted? And Munsterberg actually testified, and that's where he got the On the Witness Stand book that he wrote, and discussed that, yeah, it's generally accepted. Well, ultimately, I believe the court ruled that it wasn't something that was generally accepted at the time, but it did set the stage again for Munsterberg to be the expert witness, to be able to come in and talk about something from a standpoint of understanding. And so he was one of the first expert witnesses allowed in court. The Federal Rules of Evidence set up guidelines, and this was in 1975. They set up guidelines governing the admission of facts by parties in any kind of U.S. Federal court system there's a lot of them. There's a whole bunch of Federal Rules of Evidence, but the ones pertaining to expert witness testimony include psychological testimony should be relevant in making some fact in the case more or less probable that it would be without the testimony. Therefore, in essence, psychologists should be there to assist the trier of fact. And psychological testimony should be related to mental state, personality, or character of a defendant. The probative value of psychological testimony should outweigh the prejudicial impact, and the expert should have expertise in areas in question in a particular case. So that's what the Federal Rules of Evidence, in essence, say, as opposed to just general acceptability. There's a little bit more guidelines for expert witnesses. Well, Daubert comes along and establishes expert. And there's something called the Daubert Trilogy. It actually has three main cases with it. But the first one dealt with Daubert, Jason Daubert, and Eric Schuler. These two guys were born with birth defects, and their parents sued the Merrill Dow Pharmaceuticals because they were on a medication called Bendectin that was, they said, caused the birth defects. There was a huge court case because of all of this, and what ended up happening was Daubert and Schiller actually had some scientists prove that this drug caused birth defects in utero in mice. But what happened was the court ended up throwing it out because They said that the evidence had not been generally accepted because of a couple of reasons. One, it was specific to the case. So you can't really have evidence that was created to support a case. It has to be something that's currently standing. And it was generated solely for the purpose of the litigation. So really the admissibility of the expert witness testimony, it raises the question of the Daubert motion. If one side or the other thinks that there's something hinky going on the other side with their experts, they can require a Daubert motion, which then forces the judge to look more, to call forth the acceptability of the expert witness. Each of these different sets of admissibility standards has its advantages and disadvantages. The FRE standard really it's good, and it's probably the best Frey-like standard because it helps get rid of like junk science. It really calls for experts, but Daubert's is a little bit more restrictive. And so psychological tests like the MMPI, for example, are subjected to Daubert requirements because people will ask the expert about error rates and validity of it, and the expert might need to talk about that. So if you are acting as an expert witness, you may have a Daubert challenge for the instruments that you're using. Ultimately, the judge has the judge is the holder and the gatekeeper, and the judge says, okay, you're an expert or you're not. But the Daubert motion is, if one side or the other says, I don't think this guy's a true expert, then the judge has to make a decision. And it gave the right to both parties to be able to make that Daubert motion, you know, and have the judge really call into question the instruments that you're using. You are absolutely allowed to bring something in. And my suggestion is if you ever do receive a subpoena or are asked to be an expert witness, create yourself a binder. And in the binder, put these things. So this is the one binder that I got to create, and it includes the subpoena. It includes the report that I wrote. It includes my CV. If you also have any specialized training or credentialing, put your certificates, that sort of thing. It has an outline of all of the things that I wanted to testify about. And it has the diagnosis from the DSM. I copied it right there so I could refer back to it. And then you can always put in the back here any studies that you want to reference. Or a reference list of books or whatnot. This is discoverable. They could take it from you, make a copy of it, look through it, whatnot. So you don't want to put like a love letter or your laundry list. You don't want to put stuff in there. Keep it to court and take it to court with you. Make sure that your attorney knows about it, maybe even has a copy of it. But it's something that you can use on the witness stand. And it might get you out of being in a stressful situation. I actually, when I was preparing this lecture, I came across this interesting little thing by LaRue, I think. It was a 2-page thing in the Monitor. You might have seen it. It's an expert witness survival guide, and it's got 10 steps for things that you need to be aware of if you're going to be on the stand. Of course, learning the rules of evidence, as we've already talked about. Begin preparing the moment you take a case. The second you take a case, you're then preparing to testify. Even if you never testify, you're preparing to testify, which means that you're doing your assessment, you're writing your report, your interaction with the attorneys and collateral information, all of that, keeping in the back of your mind that you might have to be on the witness stand, you might be testifying and defending yourself. Be truthful in everything that you do. Write your report with cross-examination in mind. As you're writing up that report, every sentence that you write, you know that you might be challenged on. Insist on meeting with the attorney who retains you. I can't tell you how many times attorneys don't even bother to call you back. They say, yes, you're hired, you've got this case, they give you the initial stuff, this is your court date, and then they don't call you back because they're busy with 1,000 other things or clients or whatnot. It's on you to call them and say, I want to do some prep often. You can't know the facts well enough, so keep trying. Go over it over and over again. As an expert, your job is to teach. So you're teaching the jury. You're putting things in lay terms that they can understand. Let the weaknesses in the case be presented on direct testimony. You don't have to bring them up. Cross-examination is supposed to be a challenge of your work and credibility. It's not something that's personal, so don't start crying. Maintain professionalism. And then on cross-examination, be willing to admit the truth, but only the truth. So if you're interested, you can look up that reference. He goes into a little bit more detail about each of those. And again, as I said, if you want a reference list, I've got a 2-pager at home. So general guidelines: separate facts from inferences. Stay within the scope of the referral question. I'm always going to be coming back through this. Throughout this entire lecture, I'm going to be asking, what was the referral question? Because if you go beyond the scope of the referral question, that's problematic. Avoid information overkill and underkill. We'll get into that. And avoid jargon when you're testifying. You know, you don't have to say trichotillomania. My mom taught me that when I was 5. I have no idea why. I thought it was a cool thing, so I'd like bounce around and sing it to my mom. But I did the little hair twist, and she's like, Rachel, you've got trichotillomania. And I thought that was cool. Anyway, you don't have to tell the jury trichotillomania. You could say hair twirling. It will go over probably better. Here is the Expert Witness Association. Those of you who've testified, they have been trying to recruit me like nothing. It's crazy. But they do an annual convention in Las Vegas. And apparently it's a huge, beautiful convention with experts from all over the country. And again, email me for that reference list if you're